Mr. Chairman, my name is Joey McCutchen. I'm here with the Arkansas Transparency and Government Group. I'm also a lawyer. Mr. Steinbuck referred to two cases. He referred to McCutchen versus the City of Fort Smith, and he referred to Wade versus City of Fort Smith. I tried both of those open meeting cases. I took them all the way to the Supreme Court. I've been involved in litigation. Open meetings has been my passion for the last 10 years. I want our business done in public. I want to talk a minute about the Wade case. The Municipal League this morning made a statement, I believe, that probably we advise that two or more meeting of our governing officials or bodies is a meeting. Well, that's not what the law is in Arkansas right now regarding open meetings, and I cringe at what the law is in Arkansas in terms of transparency in government, because we wouldn't need Ms. Bentley's bill if folks on either side of this aisle knew what the law was. Here's the law, and it's not set by you. The law currently is set by the Supreme Court. I tried the case in 2012, McCutchen versus the City of Fort Smith, and the Supreme Court said at that point it's the legislature's job to define a meeting. I've been working for over 10 years to get a definition for meeting. In that case, McCutchen case, the city administrator had given an informational packet to our governing body. He also gave a recommendation as to how they should vote. After that, each of the council members called the city administrator and told them what their vote was. The Supreme Court ruled that was not a meeting. I mean, this is informational. That's why I can't understand why it would take 2 years to get an ambulance service in Prairie County, because you can have those types of discussions. The Wade case defines what a meeting is. And here's what a meeting is in the state of Arkansas. It'll shock most of you, because when I read the decision, it shocked me. And either side, the governing bodies of the citizens have no idea, and that's why we're in such a state of ambiguity. They said that to constitute a meeting, and they had to define what a meeting was. City of Fort Smith argued that you could not have an emails that constituted an email. There was an email chain, a group email chain, where 3 of the board members voted on that chain and discussed to abolish the Civil Service Commission in Fort Smith. 4 other ones were also there. But you know who wasn't there? The people. We never saw that discussion. So the Supreme Court ruled that to constitute a meeting, there has to be a directly solicited response. That is, somebody has to ask somebody to make a decision. Secondly, there has to be a decision. And thirdly, it has to involve 3/7 of the city board of directors. Our city board of directors had 7 members. Talking about driving a Mack truck in open meetings, you can drive a Mack truck through that. So if our governing bodies wanted to meet, 2 of them or 3 of them, they could do it. They just have to follow this outline. And I think that's dangerous. That's why I think there has to be a legislative definition of meeting. And one thing that concerns me has been brought up. I filed 3 FOIA bills. I helped Senator Clark with 3 FOIA bills, one on training on FOIA, one on written responses, and a third one on the definition of a meeting. That definition said that 2 or more governing bodies cannot meet and discuss our public business. And in that meeting, in that definition, we also defined it that chance meetings are not meetings. And the reason for that is because we hear all the time that Well, I met with one of my fellow council members, and we discussed the hogs, and I feel like there's going to be a violation. The public needs guidance in that area. They also need guidance in terms of legislatively whether an email chain, does that qualify as a meeting? There are all kinds of, we can do good here. We can lose the ambiguity. We can work out a compromise that does not sacrifice, in terms of secrecy. Because what Justice Hart said in her dissenting opinion in my Wade case, and by the way, I've tried all these cases not for $1, because I believe that if we have a good open meetings law, we can be efficient and we can have our public business being conducted in the public. She said in that case that today's majority opinion denies the electorate in Fort Smith insight into the performance of elected officials and allows those public officials to make their decisions in secret. Secrecy is the poison of democracy, and she dissented in that case. I want to read a quote, then I want to talk about Tennessee. Patrick Henry said, "The liberties of the people never were nor ever will be secure when the transactions of their rulers may be concealed from them."